making and our administration of misleading electoral advertising complaints. But first, I would like to acknowledge the traditional custodians of the ACT, the Ngunnawal people, and recognise any other families with connection to the lands of the ACT. We acknowledge and respect their continuing culture and the contribution they make to the life of this city and this region. Again, if you're keeping things to kick off the presentation, please use the question and answer function to ask questions throughout the session as they arise. I'll address questions at the end of the short presentation. Anyone in the room here today, if you have questions, hold on to them and we'll do those at the briefing. And for those attending virtually, please keep your microphones on mute for the duration of the presentation. Again, just to repeat the disclaimer in the presentation today, it's important to note that the advice provided today is based on elections ACT analysis of electoral law. This advice cannot be taken formal legal advice, and you may need to seek your own advice in relation to any matters discussed today may be relevant. So the ACT will be the second jurisdiction in Australia to have enacted what is colloquially known as truth in advertising laws, or what we will now and forevermore be referring to as misleading electoral advertising. These laws came to be in the ACT through Electoral Amendment Bill 2018, but the relevant clause wasn't inserted into this bill and debated until August 2020. It was notified in September 2020 and took effect after the 2020 ACT election on the 1st of July 2021. So the 2024 ACT election will be the first election in the ACT where misleading electoral advertising rules will be in place. But before we get too heavily invested in our newish clause, I want to establish an understanding that the new laws are not to be confused with the long-standing and somewhat similar clause in the Electoral Act, namely Section 297, misleading electoral matter affecting casting of a vote. To quote the Act, a person shall not disseminate or authorise to be disseminated electoral matter that is likely to mislead or deceive an elector about the casting of a vote. While this sounds very much intended to prohibit misleading electoral advertising, it is a clause that is replicated in the Electoral Acts of many jurisdictions and one that federal court has ruled upon and interpreted narrowly, focusing on the actual process of voting rather than the content or truthfulness of the political message itself. This means that Section 297 addresses misleading information about how to vote, such as providing incorrect instructions on filling out a ballot paper, rather than false or misleading statements about candidates, parties, or policies. So moving on to the clause at hand, Section 297A of the Electoral Act, which is misleading electoral advertising. So under this law, a person commits an offence if they disseminate or authorise the dissemination of an electoral advertisement that contains a statement purporting to be a statement of fact that is inaccurate and misleading to a material extent. So those elements are absolutely key to the application of these laws. For an allegation of misleading electoral advertising to be legitimate, it must involve an advertisement that, as the first hurdle, contains electoral matter. And I'll briefly pause to our exploration of the new clause to explore a very old clause, Section 4 of the Act, the meaning of electoral matter. Electoral matter is matter in printed or electronic form that is intended or likely to affect voting at an election. Something is taken to be intended or likely to affect voting if it contains an express or implicit reference to or a comment on the election, the performance of a political entity such as the government, the opposition party or a candidate, or an issue presented to electors for the election. So most things being produced and distributed by a political party or a candidate are likely to be considered electoral matter. So the next consideration is if the advertisement contains a statement purporting to be a fact. That is, it can't simply be a statement of opinion. It can't be a statement such as, I believe candidate A is going to introduce a new tax, or I think this party supports something or other. It has to be a statement of fact. This party has a policy to open or close a new such and such. Complaints that involve statements that are deemed to be opinions will not be investigated further. And then this statement has to be inaccurate and misleading to a material extent. So clearly, for the complaint to be substantiated, the statement made within the advertisement has to not be factually correct, as well as leading the audience to false conclusions. But it also has to do this to a material extent. So the Commissioner's considerations on a case-by-case basis will involve the degree to which the inaccuracy involved is significant enough to warrant remediation action on behalf of the offender. So investigations. So provided that the complaint contains all the necessary elements to facilitate an investigation and is not, in the opinion of the Commissioner, frivolous or vexatious, then the complaint will be investigated. However, when a complaint is made concerning misleading electoral advertising, the Electoral Commissioner is going to require from the complainant evidence in support of their claim. It will not be enough to say Party A published this electoral advertisement and it isn't true. It will be incumbent upon the complainant to provide all the necessary information to allow the Commissioner to make an informed assessment of the complaint. A complaint will need to provide evidence of the offending advertisement and advise the exact statement that is the focus of their misleading electoral advertising complaint. The complainant should then clearly and accurately provide as much detail as possible, including the relevant facts, the location, dates and times, and provide as much supporting evidence, including photos and relevant documents, as possible. The factors the Commission might consider when deciding whether to further investigate a matter, include whether sufficient evidence has been provided to support the complaint and the age of the material. The time frame between dissemination of the advertisement and the lodgement of the complaint may be considered by the Commissioner in determining if the complaint is deemed frivolous or vexatious. The Commissioner may then undertake investigations in order to corroborate the supporting evidence supplied. For instance, it might be necessary for the Commissioner to seek further information from either or both the complainant or the alleged offender. And while it is critical that the complainant supplies the necessary evidence to facilitate the Commissioner in making a decision, it may be necessary, in limited circumstances, for the Commissioner to seek external advice to enable a view on whether or not an advertisement is misleading and inaccurate. So, moving on to deadlines. Particularly during and through a live election campaign, the time in which matters of potential misleading electoral advertising are dealt with can be of relative critical importance, and it must be appreciated that in order to ensure due process, the Commissioner's investigation may take some time. However, we will endeavour to resolve allegations within 5 business days after the receipt of all evidence has been supplied. If the complexity of a complaint means it cannot be resolved in that time frame, we will advise as such as early as possible. But in order to meet what we view as a community expectation for resolution of misleading electoral advertising matters, it is also important to note for both complainants and the alleged offenders that if the deadline for our request for information is not met, then the Commissioner may make a determination without the information or may close the matter without further investigation. Where information is required from the parties involved, we expect any and all relevant information and evidence to be provided in the first instance. The Commissioner's decision will be based on the information provided, and it may not be possible to clarify or obtain further information before making that determination. So what happens when the Commissioner does not find in favour of the complaint? So decisions on misleading electoral advertising are made by the Commissioner on the balance of probabilities, not upon reasonable doubt. So if the Commissioner finds that on the balance of probabilities, a piece of electoral advertising is not misleading and inaccurate to a material extent, And the Commissioner will write to both the complainant and the publisher of the advertisement to inform them of the outcome of the investigation and advise that no further action will be taken in relation to the matter. However, if the investigation outcome indicates that there is evidence that the advertisement includes a statement of fact that is misleading and inaccurate, then remedial action by the person responsible for the advertisement will be required. So the Commissioner may formally write to the person asking them to do one or more of the following: to not disseminate the advertisement again, and/or publish a retraction in stated terms and in a stated way. So what that means is, as part of the request for a retraction, the Commissioner may explicitly state the manner and the form that the retraction should take. For example, if the person publishes a misleading advertisement in a newspaper, the Commissioner may request a retraction to be published in that same newspaper. Or if it's not possible to make a retraction in that same manner, then the Commissioner may state an alternative manner and form. The Commissioner may also apply directly to the Supreme Court for an order obliging the person to cease disseminating the advertisement further. This power may be utilised directly following a request for remedial action, or it could be used if the person refuses to comply with the Commissioner's determination. It is also at the Commissioner's discretion to refer the matter to the Director of Public Prosecutions for possible criminal prosecution. And it's worth noting that the maximum penalty for this offence, if prosecuted through the courts, is 50 penalty units, which equates to $8,000 for an individual or $40,500 for a corporation. So moving on to review rights. Misleading electoral advertising matters do not have a merits review process provided for by the legislation, and the Commissioner will not enter into any further discussion as to the merits following the determination made. And then finally, on to who can make a misleading electoral advertising complaint and how to do it. And the answer to who can make a misleading electoral advertising complaint is fairly simple. Anyone can. It is, of course, quite likely that it will be political participants in allegations and complaints of misleading electoral advertising, but it is also open to members of the public, should they identify something of concern, to lodge a complaint on behalf of themselves. And while each misleading electoral advertising complaint will be considered on an individual case-by-case basis by the Commissioner, where there are multiple complaints in relation to the same advertisement or material, those complaints might be investigated by the Commissioner together. So how do you lodge a misleading electoral advertising complaint? Well, first of all, it must be made in writing. And our preference is that all lodgements are made via the web form linked from our website. This web form will prompt for all the information that should be supplied when making a misleading electoral advertisement complaint, including the ability to upload documents and photos in support of the complaint. So that's our preference, but they can be lodged via email, but they must be in writing. So that does bring us to the end of this short briefing on the administration and enforcement of misleading electoral advertising. If there have been any questions lodged in the chat function, or anyone in the audience today has a question that they would like to ask, feel free to ask it now. So yep, we've got one in the audience. Yes.
On electoral advertising, what's the definition? Is it paid advertising, or can it be social media posts?
That's a really good question. And no, there is not a definition in what an electoral advertisement is. So the Commissioner will take a complaint and will review that complaint and the manner that the material has been publicised, and make a determination at that first hurdle whether the Commissioner considers it an electoral advertisement. And that may be social media posts. It will depend on its considerations. Will be things like who made that comment. Is it a candidate? Is it a party, or is it a member of the public? The time that the date and time when something like that was lodged. That they will be considerations taken into account at the lodgement of that complaint, whether further investigation is required. But yes, there is no definition.
Yeah, it's fascinating. I mean, the obvious thing is you might have a party say that a group of independents, in actual fact, are another party. That's all they are. But from what you've said, that's what they're saying. There's not a lot you can do about it.
I'm not sure I understood.
I will say a party says that I'm a lib, or I'm this bloke is not an independent. This bloke's from that party. End of story. Not debatable, and it's not true, obviously. Well, not true.
They're not saying, I think that he's a Liberal. He's saying a actual statement that
Yeah.
the person is a Liberal when they're an independent.
If it's in an advertisement, so just saying something doesn't
It's on
necessarily.
social media.
If it's on social media.
Yeah, so depending on how it's lodged, when it's lodged, the actual phrasing of the wording, then it could be considered misleading electoral advertisement.
I
Then
think
the
we should.
determination will be
We've got a
made.
case study.
I think we've got
Case study.
we have a case study.
Yeah, because in this case, the Labor Party has said all the independents are working with the Libs. They've come out with that statement.
If someone's got to make a statement in the first place to say that there is a misleading electoral advertising. So I think, to clarify Rose's point earlier on, is that we don't have the capacity or resources to be able to go and do an active search of this stuff non-stop ourselves.
Yeah.
Where this exists, that doesn't occur. So it's incumbent upon, as Rose said, someone who makes the complaint to provide the allegation of that said complaint and all the substantiation behind that complaint. Then we take it from there.
So,
And are there provisions for vexatious compliance, or is there any, like, what are the consequences of someone just constantly submitting? I'm not saying I'm going to make vexatious.
So yes, there are. And if it is deemed to be a vexatious, frivolous or vexatious complaint, then there's no obligation to investigate that further.
So basically,
So those determinations will be made on case by case basis. I think we've got any questions online. Questions?
explain a bit.
That's fine.
not designed.
One, two.
Okay, well, thank you all. As I said, we're always open
Getting to me.
to provide advice and information if you would like to contact us on any of the avenues above on the screen.
The legislation.
Otherwise, I'll bring it to a close.
So just one thing,
Misleading.
the use of satire and ridicule and those sorts of things, that becomes a grey area too for, I suppose, but that's always been accepted, just make fun of someone. Is that something you look at with a different
It's got to
view?
be a statement purporting to be a statement of fact.
Okay, yep.
Just don't make it too realistic.
You want to hear my problem?
All right. Well, thank you all for joining us. Hopefully that was informative.
Yeah,
But
that's
again,
good.
any information, any questions you may have, feel free to reach out to us.
Thank you.
No questions.
Do you ask any questions?
We should put that one in, that
Honestly. Yeah. That's terrible.
case study, because it clearly says, it doesn't say, I think that they're doing that. It says they are.
Exactly.
Let's do it. It's not going to be frivolous.
You reckon, Tom, you reckon we should put that one in?
Yeah, is it?
Oh, and by the way,